Hello, my name's Tom Kyle. It's Sunday, the 24th of November 2013. I'm making another video about the Aston Lloyd Ponzi scheme, or ALPonz. And this one concerns a barrister's opinion. This barrister was commissioned by RE10. They're the criminal insolvency, well, they pertain to be insolvency practitioners, and they just then don't do any of the things they're meant to do and just steal everything. So they're a criminal organisation. Do not be calling them insolvency practitioners, because they're not. Bijal Shah did a witness statement in support of their sort of application to the court to be made insolvency practitioners, but we've only ever seen the draft of it, so obviously the real one will be different. But anyway, they commissioned this guy, Michael Jeffries, that's Jeffries, in May 2012, to write its opinion. Now, one thing you've got to realise, you're dealing with very, very, very dodgy people here. Michael Jeffries, I'm certainly not saying he's done anything wrong. In fact, he's done a lot right. Michael Jeffries was paid by these scumbags, right, to give an opinion. And it would have been a closed question. So if you don't know how barrister opinions work, often they'll sort of give a little bit of opinions around the side, but you can effectively point them in the direction of something. And then what often happens is people will use their opinion and misapply it to other things, but they weren't asked about that, so you don't actually often get to see what they're actually asked to give their opinion on, which seems a bit strange, but that's often the way it works. And this is a common trick. But the thing with this one is, this guy makes it very clear that he does not agree with what they then imply, that they've got an opinion and he's going in the same direction as them. He's absolutely not. Now, this is quite long. I'm not going to apologise for that for anybody who likes everything to be given to them in 10-second or 30-second explanations. It's 36 pages long, but I shall proceed to read it just to make it easier. I know I'd sooner just lie down and listen to a YouTube video. I mean, or watch, but I wouldn't even be bothered watching it. What's the point of watching me talking? You know what I look like. And I was a victim of the Aston Lloyd Ponzi scheme, or I am a victim. It's an ongoing crime. It's been covered up by the police and the authorities, by the way. But this Jeffries, I'm not saying anything bad about him, and I'm not saying that because I'm worried or anything. I'm honestly saying he hasn't done anything wrong. Right? So I shall proceed to read it right now. Aston Lloyd and Partners International Limited. Opinion. 1. In this matter, I am asked to advise the joint liquidators, of Aston Lloyd and Partners International Limited, ALPIL, in relation to questions which have arisen within the liquidation of ALPIL and its related companies. The facts. 2. The facts of this matter are somewhat complex. It has been a difficult and time-consuming exercise for the liquidators to unravel the facts from a large volume of documentation, and with some assistance from the former officers of ALPIL. Sorry. I shall continue. 2. The facts. The facts of this matter are somewhat complex. It has been a difficult, and time-consuming exercise for the liquidators to unravel the facts. A bit too many commas there. For the liquidators to unravel the facts from a large volume of documentation, and with some assistance from the former officers of ALPIL. As one would expect in the real world, the paperwork was not always in the form it should have been! Exclamation marks. He's been a bit sarcastic, but bear with him. He's alright, this guy, I think. So far as the liquidators have been able to ascertain the facts, they are set out in detail. So this isn't really anything to do with his opinion, but anyway, he's probably just saying this to pander to them, do you know what I mean? So far as the liquidators have been able to ascertain the facts, they are set out in detail in the draft witness statement of Mr. Bijal Shah, which I have before me. Yeah, but why hasn't he got the real witness statement? I haven't actually picked this one up. That's actually quite interesting. Why has he been doing this off a draft witness statement as opposed to the actual witness statement? 3. The questions which arise in this case concern 8 parcels of land which are situated in four different countries: Turkey, Northern Cyprus, Bulgaria, and Slovakia. Northern Cyprus isn't actually a country, though, is it? I don't think. Is it? Maybe it is. I don't know. I thought it was just Cyprus. The sites he's put in brackets, so they'll be called the sites from the henceforth sort of thing. The sites are presently listed in the 9th schedule to the draft claim form. Some of these are bare sites. I don't know, claim form. Do you put a claim form? I don't know anyway. Some of these are bare sites and some have some buildings and or infrastructure on them. These sites are well held in the names of nominees and not in the name of ALPil itself. A large number of individuals have paid money with the intention of acquiring directly or through a nominee company. They would direct ownership of a plot of land abroad for a holiday home, or in the case of two sites, what is called a unit on a development. I will adopt the expression investor, which is used in the draft witness statement. But it should, this is point 4. I will adopt the expression investor, which is used in the draft witness statement, but it should be understood that the investors were intending to invest in real property or rights relating to real property, rather than investing in ALPil itself, e.g. as shareholders or funders of ALPil. The payments were made pursuant to written contracts which go to the heart of the matter. The sites were acquired by nominees for ALPil, but very few plots have been transferred to investors or their nominee companies, their in quotations nominee companies. The circumstances of each site appear to be different, though some can be conveniently grouped together for consideration. Whilst there were investments by ladies and companies in joint investments, and without intending any disrespect, I will refer to an investor simply as he. To save having to say he, she, it, or they every time. Urgency. 5. There is some urgency in this matter. As explained in the draft witness statement. In essence, this is because local creditors or alleged creditors or liquidators of the offshore nominee companies may force the sale of the sites. Since there is no prospect of those debts being discharged in any other way, local creditors will inevitably seek to recover their debts by selling the site as a whole. The consideration on such sales is likely to be a fraction of their market value. That said, some of the sites may be very difficult to sell in any event. There is also the problem that the sites are most likely to be sold in euros. The investors live in the sterling area and the value of the euro is presently in a downward trend, with the economic crisis particularly affecting Greece, Spain, Portugal and Italy. Right, and that was point 5 under urgency. There is some urgency. I don't know if I said that. Heading, the fundamental questions. 6. And this is, in my opinion, the fundamental questions which arise for consideration are these. 6.1. To what extent is each of the sites held as a company asset available for the general body of creditors? 6.2. And to what extent is each site subject to trusts or liens in favour of individual investors? 6.3. Like questions in relation to the balance of the net proceeds of sales of the sites which have been sold. Like questions arise in relation to the balance of net proceeds of sales of the sites which have been sold. 6.4. How to meet the burden of the cost of the great deal of work that has been properly carried out so far, and how to meet the cost of an orderly realisation of assets for the benefit of all concerned. 6.5. Should any of the sites be sold, in which case how should the proceeds of sales be applied and or any plots be transferred? Sorry. Yeah, sorry, I'll continue. I sneezed there, sorry. 6.5. Should any of the sites be sold, in which case, how should the proceeds of sale be applied and or should any plots be transferred to investors? English or foreign law? Question mark. This is the heading. Point 7. In my opinion, the starting point should be to consider what law should be applied to the issues in this case. This is me interjecting here. This is a very, very important part, just like when he's talking about the investors. You know, don't Don't worry about the fluff around the edges. Look at these salient issues, and he's put these all right at the start. This is only page 3 of 36. This is right at the start. So it's English or foreign law. Point 7. In my opinion, the starting point should be to consider what law should be applied to the issues in the case. We are dealing with the liquidation of an English company in England. Accordingly, there can be no doubt that English law should apply to the liquidation of ALPil. As regards claims by ordinary creditors of ALPil, they fall within that liquidation. As regards claims by investors, these involve real properties abroad where the principles of trust, also massively important by the way, I interject again, arising under English law may well not exist. Full stop. Parentheses. I believe that my advice may have been taken on the position in, at least, one of the relevant countries, and, if so, this can be included in the evidence before it is finalised. End of parentheses. That said, the investors' rights stem, in part, from their contracts with ALPil. These contracts all provide for any dispute arising from the contracts to be subject to the laws of England and Wales, and to be the subject to the exclusive jurisdiction of the courts of England and Wales. To the extent that the investors' rights stem not from contract but from English trust law, such as the principle of resulting trusts, there is a long line of authority that English law should be applied. The law was conveniently... that was point 8. To the extent the investors' rights stem not from contract but from English trust law, such as the principle of resulting trusts, there is a long line of authority that English law should be applied. The law was conveniently reviewed by the Court of Appeal in the case of Lightning and another, the Lightning Electrical Contractors Limited and others, 23rd of April 1998. 1998 WL 1044 250. This was a claim brought in England concerning a property in Scotland. It was alleged that a resulting trust arose in relation to land in Scotland. Although Scots law, as the nexus situs, that's LEX space SITUS, does not recognise an equitable interest, Mr. Lightning provided the purchase price for the defending company to buy a property in Scotland which was registered in the company's name. The company was an English company and Mr. Lightning lived in England. The company went into receivership, and when the receivers commenced proceedings seeking possession of the property, Mr. Lightning alleged that he was entitled to the Scottish property beneficially. Under English law and the principle of resulting trust, Mr. Lightning successfully sought a declaration against the company and the receivers that the property, or its proceeds of sale, were held on trust for him. To show the width of the principle, which is important in this case, I shall quote in full the relevant passage from the reasoning of Lord Justice Peter Gibson. The fact that a dispute relates to foreign land or involves interest in foreign land, which a court of equity in this country recognises, but the court of the foreign land would not, has never been a bar to the English court exercising jurisdiction over a person amenable to the jurisdiction. For example, by being present in England, as was stated by the Earl of Selborne, Selborne, LC, so that's Earl of Selborne, L.C, that must be his initials, in Ewing, that's Ewing, VORR, or Ewing, the same name. 18, I think that's spelled Ewing, because I've met, 1883, L.R.9H.L.34 at page 40. This is the quotation. The courts of equity in England are, and always have been, courts of conscience, operating in personam, that's P-E-R-S-O-N-A-M, and not in rem, which is R-E-M. And in the exercise of this personal jurisdiction, they have always been accustomed to compel the performance of contracts and trust as to subjects which were not either locally or rationally domiciled, it must mean, within their jurisdiction. They have done so as to land in Scotland, in Ireland, in the colonies, in foreign countries, and it's got colons 10 with 2 N's v Baltimore, and then it's got 1 VES space SEN space 444. Sounds like an American case, I'd imagine. In Duchamps, that's DESCHAMPS v Miller, 1908, 1 chapter, I think CH 856, at page 863, Parker J describes the obligation which the court will enforce as depending, and I start the quote, it's got ... on the existence between the parties to the suit of some personal obligation arising out of contract or implied contract, fiduciary, that means to do with money, fiduciary relationship or fraud, or other conduct which in a view of the court of equity in this country would be unconscionable, and do not depend for their existence on the law of locus of the immovable property. See also Dicey and Morris on the conflict of law, 12th edition, Rule 116.3.8 at pages 952 to 955. Now, I'll just point out that there, see what he's saying is equity is all to do with, and anything to do with this will always be to do with like trust and equity, trusts that have been constructed. These aren't trusts that it says you've got a trust, like as in there's a trust, your property will be held in trust. This is to do with consequential or resulting trust. This is completely different to the trust, the bogus trust issue, which was brought up, I don't know whether it was accidental or just through severe incompetence, by some guy who was investing. He had an auntie or a cousin who's a QC, and she apparently had a look at this and decided there was a trust on one of the worthless bits of land in the middle of nowhere. Now, the problem with this trust is, if you believe that that exists, that would mean that there would have had to have been a genuine contract in the first place. So effectively, you're giving legitimacy to a criminal action, because you can't have a trust if something's based in fraud. You can't have a fraud based on a trust. You can have a resulting trust, because of course, like if I stole somebody's money, that wouldn't mean they couldn't take me to the civil court to get the money back. They could. You don't lose your civil rights because you've had a crime done to you. That's a common misconception. A lot of idiots seem to think, but it's not the way it works. And they think that if the police become involved with something, you'll never get your money back. That's just what fuckwits think, right? That's bollocks. Obviously, if you believe that, you can guarantee you're not going to get your money back, but that's not how it works, right? But anyway, I'll continue in a second, but it's quite long, so I've got to bear with me because it's quite hard reading all this out without stuttering and stuff. Right, see also Dicey and Morris, blah blah blah. To these authorities can be added the more recent decision in Webb v. Webb 1991, and that's 1, I think it's a 1 or an I, WLR 1410. In that case, a father had purchased property in France in his son's name. The father brought proceedings in England against the son for a declaration that the son held the property as trustee for an order to execute the documents necessary for vesting the legal title in the father. Thus, that is a case, like the present case, where there was an alleged resulting trust. The son applied for a stay relying on Article 16.1 of the Brussels Convention. That application was refused by His Honour Judge Paul Baker QC, sitting as High Court Judge, as our High Court Judge. After review of the case from Penn v. Baltimore to Chelleram, that's Charlie Hotel Echo Lima Lima E Romeo Alpha Mike v. Chelleram, 1985, CH 409, the judge said at page 1419, fucking look at those pages, of the English proceedings, in quotes, they have as their object the establishment of the defendant's accountability as a trustee for the plaintiff. An appeal, this is end of quotes. On appeal, there was a reference by this court to the European Court of Justice, which held that the jurisdiction of the English court was not outside Article 16.1, as the action was an action in personam. Mr. Lord said that these authorities go only to the question of jurisdiction and do not go to the question of the applicable law. But, for my part, whilst that may be correct, it seems to me implicit that the English court not unnaturally regarded English law as applicable to the relationship between the parties before it, in absence of any event, governed by the Lex-ctts Act, LEX space SITUS, destructive of the equitable interest being asserted. Equitable interest. See, he's put equitable interest in there. And as you might know, if you look at my video on the winding up petition, I was named as an equitable interest. We are not creditors. None of us are creditors. We are equitable interest holders. We're victims of a crime. There was no contract. There was a fraudulent utterance, or whatever you call it. Do not fall into the category of thinking you're a creditor, because you're not a creditor. You're an equitable interest holder. You were promised something, you didn't get it. That doesn't constitute offer and acceptance. That means you're a victim of a crime. It's no more offer and acceptance than if somebody came and robbed the bank and you were the bank teller and you handed over the money. It's not a contract because you've given them the money. You've been robbed. You know what I mean? So anyway, equitable interest holder. Notice that no one at RE10 was very keen to ever mention equitable interest holders. Right, I continue. As is pointed by Millet LJ when sitting at first instance at Macmillan Incorporation v Bishopsgate Trust, number 3, 1995, W1 WLR 978 at page 989, commenting on Norris v Chambers, and that's spelled CHAMBRES, 1891, 29, Beavan, Beavan, I think that's Welsh. I think it's the Welsh word, isn't it? 246, affirmed 3 D space, that's DE space GEX, Dejex, Fisher and Jones, and Fisher spelled FISHER, not Fisher like that way, Fisher like a fish ER, and Jones 583. Where a plaintiff invokes the in personam jurisdiction of the English court against defendant, amenable to the jurisdiction, and there is an equity between the parties which the court can enforce, the English court will accept jurisdiction and apply English law as the applicable law, even though the suit relates to foreign land, in contrast to the equity which is asserted does not exist between the parties to the English litigation. For example, there has been a transfer of property to a third party with notice of an equity, but the Lex-ctts governing the transfer extinguished the plaintiff's equity. The English court could not then give relief against a third party, even though he is within the jurisdiction. It would have been a complete answer to the plaintiff in Webb v. Webb if Mr. Lord's submission was correct to say that English law relating to a resulting trust had no application to the relationship between the parties in respect of the property in France within its civil law system. The point was not taken, in my view, rightly, because it is, to my mind, obvious that in that case, the applicable law governing the relationship between the father and the son out of what had occurred was English law and not French law. So in my judgment here too, apart from the fact that the property to be purchased was situated in Scotland, there is nothing to connect Scottish law with the relationship between the persons concerned. Mr. Enlightening and LEC, who are both resident in England, sorry, that was comma, Mr. Enlightening and the LEC, who are both resident in England. No event governed by Scottish law occurred, whereby any equity arising under English law was destroyed. So what he's basically saying is if something happens in another country, the fact that it's happened in another country, if you've made the agreement in England, equity will still exist. Now, if you want to find out what equity means, I suggest you look it up on Wikipedia. Now, I'm not condoning using Wikipedia like for all your answers, because of course it's highly politicised and very biased in certain instances. But in this instance, the last time I looked at it, equity, it makes it very clear. It was all about the actual rightful owner of something. So the contract might not cover something, but you can have a case in equity. It's all about the King's Court, and that's why you get the Queen's Bench, the King's Bench. It's all to do with equity. You should look it up, because you'll soon realise that it very much applies in the ALPonz case to virtually everything, because of course there was no contract, so it can't be contract law, because it was a fraud, right? In the Lightning case, this is 9. In the Lightning case, both Henry and Millet LJJ agreed with Lord Justice Peter Gibson, and in a brief judgment, Millet LJ added, I think LJ might be Lord Judge, maybe, I don't know. Quotations: if A provides money to B, both being resident in England, to purchase landed property in his own name, but for and on A's behalf, and B does so, the consequences of that transaction are governed by English law. It would be absurd if they were governed by the law of the place where the property in question happened to be located. Such a rule would lead to bizarre results if, for example, A's instructions were to buy properties in more than one jurisdiction, for the consequences of the same arrangement might then be different in relation to different properties acquired. Sorry, I'll just read that again. Such a rule would lead to bizarre results if, for example, A's instructions were to buy properties in more than one jurisdiction, for the consequences of the same arrangement might be different in relation to the different properties acquired. And that's quite interesting, so I wouldn't have thought of that angle, but he's absolutely right. The example I would suggest that you use is, imagine if I was paying somebody to build something on the moon for me. Obviously, I'm not making the decision to do that on the moon, and there's no court on the moon, so it would obviously be where we made the agreement, or on the bottom of the sea. Let's just say, just use that as an example. If you think about things to do with equity and property, if you use that example, that's one I've always found very helpful. So you've got that courtesy of me, very helpful, makes it very much more clear. Right, so I'll continue the quote. It would also lead to bizarre results if A left it to B's discretion to choose the property to be acquired, since that would give B the unilateral power to decide on legal consequences of the transaction which he'd entered into with A. Right, now, the other way you should look at that, that's the end of the quotation, the other way you should look at that is that if these criminals took your money and they didn't put it through all these ridiculous hoops, and they just went out and just blew it all on Ferraris and houses in France without going through all these bullshit steps, would it change anything? Do you see what I mean? Because they could just go to Turkey and buy a Ferrari and say Turkish law applies. You gave us the money, we went to Turkey, we just did whatever we fucking well wanted with it. If that was the case, you see how ridiculous it would be. Right, so that's the end of page 6, and we're on point 10. In the recent case, Lux, L-U-X-E, Holding Limited, Lux Holding Limited v Midland Resources Holding Limited, 2010, EWHC 1908, CH in parentheses, comma, at para dot 38 ET space SEQ dot comma space. Mr. Justice Roth quoted at length from the Lightning case and said, I do not consider that the reasoning in Lightning is confined to the particular case of a resulting trust. On the contrary, it seems to me of general application. English legal principles, point 11. In my opinion, it is helpful to have an overview of how trusts might arise in this case, before one goes into the factual details of each site to see whether they do arise, and if so, to what extent. There are a number of factual circumstances which may arise here that could give rise to a trust, namely 11.1, and this is under vendor and purchaser. So 11.1. If an investor paid ALPonz a sum of money under an enforceable contract, see this, if, because he's not saying they did, yeah? If an investor paid ALPonz a sum of money under an enforceable contract for the sale of an identified plot of land owned by ALPonz, then pending completion of the purchase, the plot will be held on trust for the investor. C.E.G. Lysaght v. Edwards. That's L-Y-S-A-G-H-T. Lysaght v. Edwards, 1876. 2. C.H.D. 499 at 506 ET space SEQ dot space, and the review of the authorities by Lawrence, L-A-W-R-E-N-C-E, Lawrence Collins, J, in Englewood Properties Limited v. Patel. Englewood is E-N-G-L-E-W-O-O-D. Englewood Properties Limited v. Patel, 2005, 1 WLR 1961, at paras 40 to 43, full stop. This is the application of the equitable maxim that equity regards that as done that which ought to be done. The authorities show, however, that the trust only arises where there is an agreement which is capable of being subject to specific performance. Right? That's another very important thing that you need to look up. Specific performance pertains to something which is unique. Like if you had a classic car and it got crashed, you wouldn't be entitled to the price of the car when it was bought, 50 years ago. You'd be entitled, well, and maybe in certain insurance, but let's say I smashed your car up, and you were claiming against me for smashing it up, and just forget different insurance provisions you might have, I would be due to give you that car back or maintain it back. I wouldn't be due to just give you some tatty old shitty car that was built at the same time, that cost the same price at the time. It would be that specific thing. Now, when it comes to property, because you've got views, you've got a locational uniqueness, and you've got like an obviously characteristic, stylistic similarities, it's to maintain the property back to how it was, put it back to how it was whenever, whatever happened. So, like, if your house got burnt down, you wouldn't just have to move down the road and round the corner. You could have the house built brick by brick back to the initial state. That would be what they would do, give you the money for it. Specific performance, very important. A court can order specific performance of a contract, right? See, e.g. Holroyd, that's Holroyd v. Marshall, 1862, 10 HLC 191, and Cornwall, Conwall v. Henson, Henson, Cornwall v. Henson. Right. 1899, Chapter 2, 2CH 710 per Colemans-Hardy, Cozens-Hardy J, as he then was at page 714. The actual decision in Cornwall was reversed in the Court of Appeal, but on factual grounds, leaving the legal principle undisturbed. And if you followed that, you're doing better than me, because I've kind of lost what I'm talking about. Right, so that is part of 11 right now. The second part of 11.2, resulting or constructive trust. In my opinion, if an investor paid ALPonz money, which was used to purchase a site in which it was intended the investor was to have an interest, then the investor would have an interest in this site under a resulting or constructive trust. In ordinary circumstances, the interest arising under the resulting trust would be proportionate to his or her contribution to the total purchase price. Right. When ascertaining the extent of the interest under the constructive trust, the court would go wider and take the overall picture into account when seeking to ascertain the parties' actual intentions. See, for example, Drake v. Whip, Drake v. WHIPP, 1996, 2 SCR 296. 11.3. The resulting trust is different to the trust arising in the vendor and purchaser situation in two respects. See, he's talking about the bullshit trust issue. They keep calling the trust issue, which isn't a trust issue, which lends legitimacy to there being a legitimate contract in the first place. The resulting trust is different to the trust arising in the vendor and purchaser situation in two respects. One respect is helpful to a claim by an investor, and one which is unhelpful. The interest in the site may arise under a resulting trust, even if no plot has been identified, if the investor provided money which was actually used by ALPonz as part of the purchase price of the site. On the other hand, in my opinion, a payment made to ALPonz after ALPonz purchased a site would not normally give rise to an interest or large interest under a resulting trust. E.g., see Drake v. Whip, right? So that's basically it. On the other hand, in my opinion, a payment made to ALPonz after ALPonz purchased the site would not normally give rise to an interest or larger interest under constructive trust. What he's saying here, right, is he's saying that this bullshit about how you're an investor in a big Ponzi scheme pot and it all gets shared out, that's complete rubbish. He's saying that you've got no right to have something that I've paid money to actually have and has been bought, and I've been tricked into thinking it's been tricked in, I've been snided into thinking it's been transferred into my name. Other people who pay the money don't own that. I own it because it's been given to me. I have an equitable interest. I'm the equitable owner of it. That's what that means. So he's actually completely undermining everything that RV10 said, but they still used it as evidence for their own gains. Anyway, we've got another heading. ALPonz v. Morgan Trust, and that's Pallant, Pallant v. Morgan Trust. 11.4, this is. The classic case where a trust arises under the principle enunciated in Pallant v. Morgan is where there is an arrangement or understanding between two competing parties that one will purchase a property and the other will have an interest in the property, and the arrangement or understanding clauses the latter to stay out of the bidding for the property. See Parent v. Morgan, 1953, Chapter 43. More recently, the Court of Appeal has widened the principle. The Court of Appeal has held that the non-acquiring party's agreement to stay out of the market was not a necessary feature, nor did the arrangement have to be contractually enforceable, but it is essential that the circumstances make it inequitable for the acquiring party to retain the property for himself in a manner inconsistent with the arrangement or understanding on which the non-acquiring party acted. So the non-acquiring party would be us. We acted according to their representations, and then they didn't do what they were meant to do, right? C, Banner, that's B-A-N-N, Banner Homes, sorry, did I say B-A-N-N-E-R? Banner Homes Limited v. Luff Developments, Luff spelled L-U-F-F, Luff Developments Limited. So Banner Homes Limited v. Luff Developments Limited, 2000, Chapter 372. Whilst the investors were not competing with ALPil for any of the sites, the wider principle could apply where they paid money under an arrangement to acquire a plot on a site and ALPil, or rather its nominee, purchased the site. Notice he said its nominee, because the way a lot of people have been talking as though you can kind of like have a nominee company that you completely control and then it's just got like a mind of its own and you're not liable for anything it does. But, you know, it's fucking obvious that's not how it works. Anyway, Express Trust 11.5. In order to create an enforceable trust of land, one would need at least something in writing signed on behalf of ALPil to comply with Section 53(1)(b) of the Law of Property Act 1925. If an investor paid money to ALPil and ALPil declared that it held the money or declared that it would hold an asset representing the money on trust for the investor, then, in my opinion, a trust would arise. This situation that arises in this case is, alas, not quite as simple as that. There are no formal declarations of trust. In relation to some sites, ALPil takes on a contractual obligation to procure that its subsidiary will hold the relevant plot on trust. Yeah, but they've made a representation, so it doesn't actually make your case weaker, it makes it stronger, because, of course, if they've deliberately not done something, it's like the example, if you go into the bank and try and rob it with a gun, the fact that there's no paperwork saying you've stolen anything isn't a strength of the bank robber, is it? Just because nothing's in the right, well, why would they write it down? Because they've just gone and blatantly robbed it. So the absence of there being any paperwork is actually strength to the argument that they've stolen it, because otherwise they would have actually done what they said they were going to do. Right, 11.6, proprietary estoppel, that's spelled P-R-O-P-R-I-E-T-A-R-Y, estoppel, E-S-T-O-P-P-L-E-E-L, sorry. The three requirements for an interest to arise under the doctrine of proprietary estoppel are: 1. A promise or assurance by ALPil, 2. Reliance by an investor, and 3. Detriment to the investor. See Thorner, Thorn spelt like a thorn, E-R, v Major, M-A-J-O-R, no U in it. So Thorner v Major, HL 2009, UK HL 18. In some sites, ALPil could be said to have represented to investors that the investor would acquire a plot. If the investors paid the purchase price in reliance thereon, the investors acted to their detriment and paid the purchase price. The appropriate remedy where an estoppel arises is the discretion of the court, but the court will satisfy the equity by awarding the minimum necessary to do justice. In a case such as this, the award could be a declaration that the plot is held on trust for the investor, or an award of a sum of money equal to the sum paid by the investor, and this is or the value of the relevant plot of land, if lower. Right, so that's interesting. Again, it totally undermines everything else that they've actually done. 11.7. There is an authority that, when distributing the statutory estate in a liquidation, estoppels do not run against the liquidator for two reasons. The representation must be made by the person sought to be bound. Here, the representation would have been made by ALPil and not by the liquidators. And 2, to allow estoppel to inflate proofs of debt would distort the obligations under the statutory scheme for the distribution of assets of the company in liquidation. C. In re. Exchange Securities and Commodities Limited in liquidation 1988. 1. Chapter 46 at page 55 et space sec SEQ. It should be noted, however, that in re-exchange securities, the investors were to be, I don't really know why they put re, because it's re and then exchange securities, so it's not re isn't part of the name, I don't think. It's exchange securities. I think he might have mean like, in relation to, he probably means it, I think. Exchange of securities. The investors were to be allowed to prove for the sums which they invested. They were not allowed to recover for the fictitious profits which the company represented they had made. So that would be specific performance, in other words, yeah? You would get what you were, meant to get, not some inflated value of it. You'd get the actual thing or the value of it as it actually would have been if it could have been built. So, for instance, you got Tuzla Lake. Couldn't have even built the properties. They didn't build them, but there was no such place. The actual address didn't exist because it was like registered in one borough, and it was actually in a different province. So it was like, so the address skipped from two places. So it'd be a bit like having a house in Toxteth, in Salford, in Greater Manchester, in Merseyside. It doesn't make any sense because it's in two different. They're two places next to each other, and as it goes, the address bumps between two of them. It was not in Bodrum. The actual place is next to Bodrum, but they said it was in Tuzla Lake, which is in Bodrum, but it's not. Like, if you can understand that, but you're not going to be able to because it doesn't make any sense because it's fraud. Anyway, 11.8. Quist Close Trust. That's Quistclose. A Quist Close Trust arises where money is advanced to be used for a particular purpose and no other purpose. If it cannot be used for the stated purpose, then it is held on trust for the person or company that advanced the money, e.g. Barclays Bank v. Quist Close Investment Limited 1970, AC 567, and Twin Secra v. Yardley. Twin Secra spelt twin, SECTRA, v. Yardley, YARDLEY, 2002. 2. AC 164 AT space P, page 186 et sec. Look at the contrast in this case. I cannot see any term requiring purchase monies to be used for one purpose and one purpose only. Right? I cannot. In my opinion, such a term is not required to give business efficacy to any purchase contract, and such terms should not be implied into any of the contracts. Well, I think the memorandums of sale, maybe you haven't seen them, but I would say that's probably wrong. The fact that ALPonz was making a profit on the sale of each plot militates, M-I-L-I-T-A-T, I've never even heard that, militates strongly against a quint close trust. A quint close trust arising in relation to the purchase price paid. Furthermore, ALPonz, so what he's basically saying, I think, is he's saying there's no way you'd get this quint close trust because they were clearly making a profit, so you wouldn't get the actual price you paid because that includes profit. So specific performance doesn't take account to the actual profit. It would take how much it would cost to actually get that actual thing, which doesn't necessarily entail profit, does it? Especially if the profit is massively overstated. Right, anyway, the fact that ALPonz was making a profit on the sale of each plot militates strongly against a quist close trust arising in relation to the purchase price paid. Furthermore, ALPonz appear to have applied any money it received towards any project. ALPonz appeared to have applied any money it received towards any project or administration costs, just as it pleased. So ALPonz did not consider it was duty bound to apply any funds in any particular way. Right, but there's a law you've got to remember. I can't remember what it is, how you say it in Latin, but any you mustn't take any influence from something's abuse. So if somebody's lying about something, you can't base laws based on that or precedent based on that. So that's it. It's any conclusion about something by its abuse is, invalid in law, something like that. So just remember that. It's a legal maxim. It's very important to remember with everything to do with Aston Lloyd and Holdings Partners. Aston Lloyd, ALPonz, the whole lot's a Ponzi scheme. So, don't get confused that there's lots of little different companies. They're all part of the same thing. It's just been conveniently ignored by all the people trying to cover it up. 12. I shall now turn to consider the different sites in more detail, and I will consider them in the order they are addressed in the draft witness statement. I'll stop.